Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal educational content. And today will be the day I earn that subscription. For today's evening story, we are dealing with another case from the Supreme Court Great Case Series, which deals with religious discrimination in unemployment benefits. This is a case of Sherbert versus Verner. In this case, the appellant was a Seventh-day Adventist, which means that she celebrates her holy day on Saturday. She was fired from her job and she was seeking unemployment, but she would not accept any job where she had to work on Saturday because it was a religious holiday for her. So the South Carolina unemployment office denied her unemployment benefits because in order to receive unemployment in South Carolina then as now, you have to be willing to work, and they will help you find work. And if you're unwilling to accept work, you can't get unemployment, right? And she says, well, I'm unwilling to accept any job that requires me to work on Saturday. I'll work any job that requires me to work any other day of the week, but not Saturday. They say, well, that's not good enough. You're required to work on Saturday. Now, of course, South Carolina then as now would not force you to work if Sunday was your holy day. Right? Because that's the common day for the holy day is Sunday. But Saturday, not so much. All right, so we are suing the state of South Carolina because we are denying unemployment benefits. We're denying a government benefit, and we're doing so on the basis of what appears to potentially be a religious discrimination. Okay? Because we'll give it to you for Sunday, but not for Saturday. All right, so let's go ahead and read this decision. Read what the court has to say. Let's learn a little bit from this case. It'll be fun for us all. All right, so Justice Brennan is writing the decision of the U.S. Supreme Court, and we will discuss it. The appellant, who is a member of the Seventh-day Adventist Church, was discharged by her employer, which is to say fired, because she would not work on Saturday, which is the Sabbath day of her faith. When she was unable to obtain other employment because of conscientious scruples of taking Saturday work, so no one else wanted to hire her either, she filed a claim for unemployment compensation under South Carolina's law. The law provides that to be eligible for benefits, the claimant must be able to work and be available for work. And further, that the claimant is ineligible for benefits if he's failed without good cause to accept available suitable work when offered to him by the employment office or the employer. So yeah, you have to be able and willing to work. And if the employment office finds you suitable work, or the employer finds you suitable work and you refuse to accept it, we're not going to keep giving you unemployment because you could work. You're just choosing not to, and that's not what unemployment is for. The appellee, which is the Employment Security Commission, in administrative proceedings under the statute, found that the restriction upon availability of Saturday work brought her within the provision for benefits that for workers who fail without good cause to accept suitable work. So you're saying you won't work any Saturdays, but Saturday is a day that people work. So if you're unwilling to work those days, that means that you're just not willing to work and we're not going to pay you. Okay. The unemployment office's finding was sustained by the Court of Common Pleas for Spartanburg. That court's judgment was in turn affirmed by the South Carolina Supreme Court, which rejected the contention that as applied to her, the disqualifying provisions of the statute abridged her right to freedom of religion. So yeah, this is one of the differences between a facial challenge and as an applied challenge. Is there anything wrong with the statute on its face? No, there's nothing wrong with it on its face. But there's something wrong with it as applied to her because she's a Seventh-day Adventist and she doesn't want to work on Saturdays. Okay. So she's saying, okay, that's a First Amendment violation to me. Okay. The state Supreme Court held specifically that appellant's ineligibility infringed no constitutional liberty because such a construction of the statute places no restriction upon an appellant's freedom of religion, nor does it in any way prevent her exercise of her right and freedom to observe her religious beliefs in accordance with the dictates of her conscience. Okay, I mean, at least not overtly again, right? There's nothing on its face. So they're saying, well, there's nothing wrong with it on its face. which isn't necessarily the end of the analysis, but it's where South Carolina stopped. It's like nothing wrong with this on its face. Okay, the U.S. Supreme Court says we noted probable jurisdiction of the appeal. We reverse the judgment and remand for further proceedings. All right, great. Let's discuss why. The door of the free exercise clause stands tightly closed against any governmental regulation of religious beliefs. Government may neither compel affirmation of a repugnant belief nor penalize or discriminate against individuals or groups because they hold religious views abhorrent to authority. So we can't do anything that goes to your religious beliefs. You're still allowed to live free in your own head. Nor employ the taxing power to inhibit dissemination of particular religious views. Again, right, this is the law as it is today, right? Can you tax people who are distributing books in general? Yes. Even if those books are the Bible? Yes. Can you have a special tax for religious books? No. Right? Religious neutrality, right? For example, as we learned from Smith, right? So we can't use the taxing power to favor certain religious beliefs over other religious beliefs, or even religious beliefs over non-religious beliefs, or vice versa, right? Religious neutrality. Okay, on the other hand, the court has rejected challenges under the Free Exercise Clause to governmental regulation of some overt acts prompted by religious beliefs or principles, for even when the action is in accord with one's religious convictions, it's not totally free from legislative restrictions. Right. And this generally is true now under things like Smith, right? We can regulate actions that are religious in nature as long as we are regulating them on the same basis and same terms as their secular counterparts. So, right. The conduct or actions so regulated have invariably posed some substantial threat to public safety or order. Yeah, we're not completely stupid, because if we allowed people to do anything in the name of religion, a lot more things would be said to be in the name of religion. Because of course you're allowed to have any religion you want, even if it's a religion of one. So if you could do any action in the name of religion, that'd be a bit of a problem. So we're not that dumb. Great. Plainly enough, appellant's conscientious objection to Saturday work constitutes no conduct prompted by religious principles of the kind within the reach of state legislation. Her desire to not work on Saturday is not one of those things, whatever those things are. Therefore, the decision of the South Carolina Supreme Court is to withhold appellant's constitutional challenge. It must either be because her disqualification as a beneficiary represents no infringement by the state of her rights, or because any incidental burden on the exercise of rights might be justified by a compelling state interest in the regulation of a subject within the state's power to regulate. Fine. We first turn to questions where a disqualification for benefits imposes any burden on free exercise. Okay, fair enough. The government is giving out some sort of thing. They're not giving the thing to you. They're disqualifying you. Does that pose a burden to your religious belief or the exercise of your religious belief? Supreme Court writes, we think it's clear on that it does. In a sense, the consequences of such disqualification to religious principles and practices may only be an indirect benefit or indirect result of welfare legislation within the state's general competence to enact. It's true there's no criminal sanction to compel work to a 6-day week. Yeah, so you're not trying to make it like criminal, but right, it's still a state benefit. So yeah, it's not a crime, but yeah, this is only the beginning, not the end of our inquiry. If the purpose of effect of a law is to impede the observation of one or all religions, or is to discriminate invidiously between religions, that law is constitutionally invalid even though the burden may be characterized as only indirect. So, yes, if the purpose or effect impedes religion, then it's invalid even despite its neutrality. Like, right, we can go too far with the whole like religious neutrality thing. Like we can't scorch earth this thing. We can't, in the name of like, if our goal is to eliminate religious practice, right, we can't, as some sort of scorched earth mechanism, just ban like all churches and whatever the equivalence to that would be, right? That might be religiously neutral in some sense. If we could figure out what the equivalent to like all churches would be in the secular context, if we just banned everything, then I guess it would be neutral. But the Supreme Court says, no, not even that, because there's a limit there too. If it is so impeding the observation to discriminate invidiously, it's like, yeah, there's an upper limit there. Here it's not only apparent that appellants declared ineligibility for benefits derived solely from the practice of her religion, yeah, but the pressure upon her to forego that practice is unmistakable. Yeah. The ruling forces her to choose between following the precepts of her religion and forfeiting benefits on the one hand and abandoning the precepts of her religion in order to accept work on the other hand. Yeah, you're putting in her in a position where she has to accept one or the other. Government imposition of such a choice puts some kind of burden on her. The free exercise of religion as a fine imposed against her for Saturday worship. Yeah, it's in effect the same, or it can be viewed as effect the same, or at least comparable. Like if we find you for worshiping on Saturday versus we're not going to give you a benefit for working on Saturday, those could be viewed as comparable rules. Yeah. Nor may the state of South Carolina court's construction of the statute be saved from infirmity on the ground that unemployment are not a right but a privilege. Yeah, no, that's not going to work, guys. Right? It may be a privilege, not a right. Fine, because South Carolina might very well be able to end all unemployment benefits. That would be the distinction, by the way, of what makes it something a right versus a privilege. Can South Carolina just quit all unemployment benefits? Yeah, I think so. I can't think of any reason they can't. Right? I mean, they could, whether or not that's a good idea or not, but they could. So they're like, this is a privilege. But it's a privilege being extended by the government. And when the government acts, there's that whole freedom of religion thing. So, doesn't really matter, does it? It's too late in the day to doubt the liberties of religion and expression may be infringed by denial or placing conditions on the benefit of privilege. Yeah. Yeah. For example, in Fleming, the court recognized that with respect to federal Social Security, the interest of a covered employee under the Act is of sufficient substance to fall within the protection from arbitrary action afforded by due process. Does the federal government need to do Social Security? No. But once they do, can they just act arbitrarily in denying it? Nah. Right? That's not going to fly. In Spicer, we've emphasized that conditions upon public benefits cannot be sustained if they so operate, whatever their purpose, as to inhibit or deter the exercise of First Amendment freedoms. Incidentally, this also extends in a freedom of speech context under different case law of the idea of unconstitutional conditions, right? So one of the things the state does, and this is not the case on point for this, but it just reminds me of something. And so I'll teach you about something else, right? So one of the things, and I've seen it more in a freedom of speech context than a freedom of religion context, is the idea of unconstitutional conditions, right? So the government says, okay, we are going to extend a benefit to you that you can apply for, but as a condition of getting this benefit, as a condition of the money, and you guys like money, right? As a condition of the money, you have to agree to waive your First Amendment rights, right? In some sort of domain, right? You have to agree in order to do this governmental program, in order to apply for this governmental program, in order to get this governmental program, in order to get this license, whatever, right? You have to agree, like by contract, essentially, to forfeiting or waiving your First Amendment rights. Now, no, right? When it comes to the government, no. Because that's an example, for example, of an unconstitutional condition, right? They can't take away from you by agreement, even with an incentive, something like your freedom of speech, because that would be really dumb. So you run into these unconstitutional condition problems. And thank you for Law and Lumber and everyone who's coming along the way. We are currently discussing this case from the 1960s dealing with religious discrimination. In the case in question, this woman was fired from her job because she wouldn't work Saturdays. She wouldn't work Saturdays because she's a Seventh-day Adventist, which by a nature of her religion, Saturday is her holy day as opposed to Sunday. So she was fired for not working Saturdays. She's applied for unemployment. The unemployment office won't give her money because she refuses to work Saturdays. And so the U.S. Supreme Court is deciding whether or not this is cool or not. Can the state of South Carolina not give unemployment benefits to this woman because she won't work Saturdays because of her religious beliefs? Amazingly, the answer is no, South Carolina can't do that. Let us continue. Okay, continuing on. We there struck down a condition which limited the availability of tax exemption to those members of an exempted class who affirm their loyalty to state government granting exemption. Yeah, that's like, no. Like, pledge your loyalty in order to get the money. When it's the government, again, we have some problems. While a state was surely under no obligation to afford such an exemption, we hold the imposition of such a condition upon even a gratuitous benefit, like we didn't have to. We didn't have to. It's gratuitous. We didn't have to. But inevitably deterred or discouraged a First Amendment rights of expression, and therefore threatened to produce a result which the state could not command directly. Unconstitutional condition. You see this in the First Amendment arena. The state cannot, by contract, get you to waive your First Amendment rights. Unconstitutional condition. Like, we didn't have to offer the money. You know, it's a consideration. No, not so much. No. To deny an exemption for claimants who engage in certain forms of speech is in effect penalize them for the speech. Right. Likewise, to condition the availability of benefits upon this appellant's willingness to violate a cardinal principle of her religious faith is also a penalty. Right. Unconstitutional condition, right? In effect, as applied, right? Because in some of these examples that they're talking about from history, it was facial. Like, it was just like literally waive your First Amendment rights. And so it's just like in the face of the statute, right? In those examples. This is not a facial challenge. This is an as applied challenge. The rule as written is neutral, but as applied to her, infringes on her freedom of religion. And so it's unconstitutional condition because it's basically give up your religion in order to get unemployment benefits. No, not so much. So significantly, and this is like the biggest problem of it all, like if you're looking for one big problem, significantly, South Carolina expressly saves the Sunday worshiper from having to make this choice, which we hold infringes on that religious liberty. Yeah, that's kind of the big problem, right? Like, if South Carolina didn't exempt anyone and they treated all the religions the same and said, you know, you have to be willing to work every single day of the week, and including on Sundays, then we'd be in a different position. We might reach the same conclusion, incidentally. We might reach the same conclusion for reasons we've discussed earlier in this case, right? There are limits, even if you're treating all the religions neutrally. Even if you're treating all the religions neutrally comparable to their secular counterparts, there are limits, right? That's Smith. Smith does eventually break down at some point. Even if you're treating the religion equally to the non-religion, it breaks down at some point. But at least we would have a different argument. Here, by exempting the Sunday people for their religious beliefs, now we have an equal protection problem. So if the First Amendment analysis isn't doing it for you, then we'll move on to the Equal Protection Clause, because now you're treating members of some religions differently than other religions for the exact same thing. And that's kind of a bit of a constitutional no-no. You can't do that. So if the First Amendment analysis would break down for you, the Equal Protection Clause is here to rescue big time. When in times of national emergency, the textile plants are authorized by the State Commission of Labor to operate on Sunday, the relevant state law says that no employee shall be required to work on Sunday, even in a time of national emergency. who is conscientiously opposed to Sunday work, and if any employee should refuse to work on Sunday on account of the conscientiousness objections, he or she shall not be jeopardized in his seniority by refusal or discriminated against. Even in times of national emergency, South Carolina said, you don't have to work Sunday if it's a religious conviction. Yeah, we got equal protection problems out the ass. No question of the disqualification of a Sunday worker for benefits is likely to arise, since we cannot suppose an employer will discharge them in violation of the statute. Yeah. The unconstitutionality of disqualification of the Sabbatarian is thus compounded by religious discrimination, with South Carolina general scheme necessarily affects. Yeah, if we didn't have First Amendment problems, we got equal protection problems right out the ass. So, yeah. No employer is likely to fire you in South Carolina in 1959 for failure to work on a Sunday. So, yeah. Great. So not so much with the Saturday worshiper. We must next consider whether there's some compelling state interest enforced in the eligibility provisions. Okay, let's see if we can make this work. We definitely can't, but let's try. It is basic that no showing merely of rational relationship to some colorable interest will suffice. In this highly sensitive constitutional area, only the gravest abuses, endangering paramount interests, give rise for permissible limitation. Basically, strict scrutiny, by other words. Does South Carolina have a reason for doing this? I'm not even really sure they have a reason for doing this, incidentally. I'm not 100% sure we can make it past rational basis on the equal protection clause issue. So that's not looking great. Because, like, what is your... This is like... So just ignore the First Amendment for just 1 minute. Okay? And let's say, okay, South Carolina, you say that, like, anyone who is a Protestant cannot work Sundays, but anyone who's a Seventh-day Adventist or Jewish or whatever has to work Saturdays. Okay, completely ignoring the First Amendment for just 1 moment. What is your rational basis for that? Because, last time I checked in 1959, there were a lot more Protestants than Catholics who took Sunday off. So if your argument is the economy, you are exempting basically the entire workforce from working. So it even goes against those interests. So, like, what is even your rational basis for treating these two things disparately? It's not going great. It's not going great. Here's a group of people that want to take Saturday off. Here's a group of people that take Sunday off. What is your reason for treating them differently? So a rational basis isn't really looking good. So we're definitely not making strict scrutiny over here. When you're failing rational basis review, you know you're having a bad day. Anyways, continuing on, no such abuse or danger has been advanced in the present case. Yeah. The appellee suggests no more than the possibility that the filing of fraudulent claims by unscrupulous claimants feigning religious objections to Saturday work might not only dilute the unemployment compensation fund, but also hindering the scheduling by employers of necessary Saturday work. But that possibility is not present here because no such objection has been made before South Carolina. Incidentally, they can do this analysis today, right? The state cannot challenge your beliefs, but they can challenge that you actually believe them. That's true today. So they can't question a religious belief, but they can question that it's your religious belief because maybe you're faking it. And so, yeah, you can do that today. You can have that kind of discussion, but that's not the objection. It's not, we think she's faking it. Yeah. So it doesn't really present itself. So, and we're unwilling to assess the importance of this interest without the views of the state court. Yeah, that thing wasn't brought up, and we're not bringing it up now for the first time as the Supreme Court because that's not how we roll. We don't usually bring up things for the first time here. So I appreciate your argument about the fraud and all, but, you didn't mention that at any stage below, so go away. Nor if the contention had been made below, would the record appear to sustain it? Because there's no proof whatever to warrant such fears, a malingering or deceit, as those of the response now advance. So even if you had preserved the issue, we still think it's dumb. Even if considerations of such evidence is not foreclosed by prohibition against judicial inquiry into the truth or falsity of that belief, citing Ballard, which remains good law today, you can question the legitimacy of the belief. That you can do. A question as to whether we intimate no such view is not before us. It is highly doubtful whether such evidence would be sufficient to warrant a substantial infringement of religious liberties. Yeah, I mean, even if a person is going to be denied their benefits because they're a faker, we can deal with that on an individual level. Thank you very much for the 10 gift memberships, by the way. I appreciate them. I'll read the rest of the super chats at the end. But I appreciate the gift memberships. They really help the channel quite a lot, and they're very, very appreciated. Thank you. For even the possibility spurious claims did threaten to dilute the fund and disrupt the scheduling of work, it would plainly be incumbent upon the appellees to demonstrate that no alternative form of regulation would combat that without infringing the right. So, even if everything you're saying is true, you'd actually have to prove it. You can't just speculate your way into there. You actually have to prove this would deplete the fund and render it inept before we're even going to consider things like this, which, no. In that respect, then, the state interest asserted in the present case is wholly dissimilar to the interests which were founded to justify less direct burdens on religious practices in Braunfield. The court recognized that the Sunday closing law, which made the decision sustained, undoubtedly served to make the practice of Orthodox Jew merchants' religious beliefs more expensive, but the statute was nevertheless saved by the countervailing factor which finds no equivalent in the instant case, a strong state interest in providing one uniform day of rest for all workers. There you go. If we're just going to close all the stores and we have to pick a day because we want to not have people working 7 days a week because we think that's bad. So it's an employment protection measure. So we're going to limit people's work hours, and we're going to even limit their work days. And we're going to say no work on Sunday for anybody. Okay. I mean, that's a religiously neutral law by its own application. No one's saying that the, Jewish person has to work on Saturday. And it's true that your competitors can work on Saturday. But the state interest here is, we want to give a day off for everybody. Pretty much everyone here has Sunday as their religious day. So it would be the most logical day to pick because it's the day that most people want to take off anyway. So, it just makes sense. I can appreciate that logic. That makes sense. The secular objective could be achieved only by declaring the Sunday to be the day of rest. We want to give everyone a day off. We had to pick a day. Sunday seemed the most logical. Okay. Requiring exemptions for Sabbatarians, while theoretically possible, appear to present an administrative burden of such magnitude or only afford the accepted class so great a competitive advantage, the requirement would have rendered the entire statutory scheme unworkable. So either it would be difficult to enforce, because presumably we'd have to inquire as to those people's religions, or those people being the only people who will open on Sunday would give them an unfair competitive advantage, which would pressure everyone to work on a Sunday, which kind of defeats what we're trying to do. So, okay. I mean, whether or not you find those as compelling or not as the Supreme Court, at least it kind of makes sense on some level. As a worker protection measure, we want to make sure everyone has Sundays off. Okie doke. In holding as we do, plainly, we are not fostering the establishment of Seventh-day Adventism. This was one of the arguments by South Carolina. We can't recognize their right to have Saturday off, because if we did, we'd be establishing the Seventh-day Adventist religion. No. You're not establishing the religion by recognizing they don't want to work that day. You're simply giving them the same exact courtesy you do to everyone else. No. For the extension of unemployment to the Sabbatarians in common with the Sunday worshippers reflects nothing more than government obligation of neutrality in the face of religious differences. Right. And does not represent the involvement of religion with secular institutions, which is the object of the Establishment Clause. Right. Nor does the recognition of the appellant's right to unemployment benefits under the state statute serve to abridge any other person's liberty. Right. Whether or not she gets money for unemployment really doesn't do anything in any respect to infringe anyone else's religious beliefs. Like at all. Nor do we, by our decision today, declare the existence of a constitutional right to unemployment benefits on the part of all persons whose religious convictions are the cause of their unemployment. This is not the case in which an unemployment's religious convictions serve to make him a non-productive member of society. So, like, again, right, we are not going to just say, like, any religious beliefs, because then, well, my religious beliefs are I can't work every day of the week, and so I need unemployment because I'm committed to my religion full time, and I can't work any day of the week. Well, it might be a pretty popular religion. So, yeah, we're no. Finally, nothing we say today constrains the states to adopt any particular form or scheme of unemployment compensation. So, South Carolina's mechanism of doing this isn't necessarily the only way of doing this. You could not have unemployment. You could do some other thing, but you can't do this. Our holding today is only that the South Carolina may not constitutionally apply the eligibility provision so as to constrain a worker to abandon his religious conviction respecting the day of rest. The holding reaffirms a principle we've announced a decade and a half ago, namely that no state may exclude individual Catholics, Lutherans, Mohammedans, Baptists, Jews, Methodists, non-believers, Presbyterians, or the members of any other faith because of their faith or lack of it from receiving the benefits of public welfare legislation. So, yeah. In the view of the result we have reached under the First and 14th Amendment guarantee of free exercise of religion, we have no occasion to consider appellant's claim that denial of benefits also deprived her of equal protection of the law. So as I said, if you weren't going to do this under a First Amendment analysis, you could just do this under a 14th Amendment analysis. So they're like, well, we're not going to consider the equal protection argument. But at least to my mind, I think that's even, I mean, I'm not sure what it says about anything, but I think it's the more compelling argument. Maybe because it's just more obvious. The equal protection argument just seems like more obvious. It's like you're giving all the people Sunday off, but you're not giving her Saturday off. It's like the equal protection argument is actually more compelling to my mind. But maybe that's just me. So I might be a concurring vote on this one. Because I think my primary rationale would be equal protection rather than the First Amendment. But whatever it takes to get to the end of the page, right? The judgment of South Carolina is therefore reversed and the case is remanded for further proceedings, not inconsistent. And then Justice Douglas gives a concurring opinion. Stewart gives a concurring opinion. And is there any dissent in this? Oh, there is a dissent from Harlan. Justice Harlan, interesting. Justice Harlan's a pretty smart guy, with whom Justice White joins dissenting. Let's read a little bit of this dissent from Justice Harlan. This might be interesting. Today's decision is disturbing both in its rejection of existing precedents and its implications for the future. The significance of the decision can best be understood after examination of the state law in play. Looking at the state law in play is usually a good place to start. Go to the text, right? South Carolina's unemployment law, enacted in 1936 in response to grave social and economic problems that arose during the Great Depression. As stated in the statute itself, economic insecurity due to unemployment is serious menace to health, morals, and welfare of the people. Involuntary unemployment It is therefore a subject of general interest and concern. The achievement of Social Security requires protection against this greatest hazard of our economic life. This can be provided by encouraging the employers to provide more stable employment and by the systematic accumulation of funds during periods of employment to provide benefits for periods of non-employment, thus maintaining purchasing power and limiting the serious social consequences of poor relief assistance. Okay? Thus, the purpose of the legislature was to tide people over and to avoid social and economic chaos during periods when work was unavailable. But at the same time, there's clearly no intent to provide relief for those who, for purely personal reasons, were or became unavailable for work. In accordance with this design, the legislature provided that an unemployed insured worker shall be eligible to receive benefits for that respect to any week only if the Commission finds he's able to work and available for work. The South Carolina Supreme Court has uniformly applied this law in conformity with clearly expressed purpose. It's consistently held that one is not available for work if his unemployment has resulted not from inability of industry to provide a job, but rather from personal circumstances, no matter how compelling. Yeah, but like the problem is that you give everyone Sunday off, and so the nature of the discrimination is religious. So religion gives extra protection. And so now you have to justify disparate religious treatment. Okay. And then they cite some case in which a claimant was unavailable for work when she became unable to work a third shift and limited her availability to the other two because they need to care for 4 children. I mean, yeah, but that's not a religious thing. So, yeah. Also, okay. In the present case, all the state court has done is to apply these accepted principles. Since virtually all the mills in the Spartanburg area were operating on a 6-day week, okay, the appellant was unavailable for work and thus ineligible for benefits when personal considerations prevented her from accepting employment on a full-time basis in the industry and locality in which she worked. The fact these personal considerations sprang from a religious conviction was wholly without relevance to the state's court's application of law. Thus, in no proper sense can it be said the state discriminated against the appellant on the basis of her religious belief, or she was denied benefits because she was a Seventh-day Adventist. She was denied benefits just as any other claimant would who was not available for work for personal reasons. I'm trying to give this its weight and due. All right. So we're not discriminating her on the basis of religion because we're treating her equal to her secular counterparts. Because many people might have reasons for not working on Saturday for personal reasons. And so we're treating her the same as all those people. Yeah, but it seems like the statute says something about Sunday workers, which is religiously based. It talks about Sunday workers with personal convictions. That seems to be religiously sprung. I'm having a hard time giving Justice Harlan the benefit on this one. I'm not quite following this reasoning here. With this background, the court's decision comes into clear focus. What the court is holding that if the state chooses to condition unemployment compensation on the appellant's availability for work, it's constitutionally compelled to carve out an exception and provide those benefits for those whose inability is due to religious convictions. Okay. Such a holding has 2 particular significance in 2 respects. First, despite the court's protestations to the contrary, the decision necessarily overrules Brownfield, which held that it did not offend the free exercise clause of the Constitution for state to forbid a Sabbatarian to do business on Sunday. The secular purpose of the statute before us is even clearer than that in Brownfield. Is it? And just as in Brownfield, with exceptions to Sunday closing laws, for Sabbatarians would have been inconsistent with the purpose to achieve a uniform day of rest and would have required a case-by-case inquiry into religious beliefs. So here, an exception to the rules based on religious convictions would necessitate judicial examination of those convictions and would be odd with the limited purpose of the statute to smooth out the economy during periods of industrial instability. But South Carolina didn't say unemployment benefits were only available if like some significantly large percentage of the workforce became available, unavailable for work, right? If South Carolina's purpose in the unemployment statute was to create relief in the event of widespread unemployment, a la the Great Depression, right? If that was truly their purpose, then they could have said, well, there's no unemployment benefits for anybody unless unemployment is greater than X percentage, right? So if that's their purpose, they could just say that, like, and they could give them mechanisms for measuring that and say, well, okay, well, no one gets any unemployment unless the unemployment rate is above X. So I don't. So he says the purpose of the statute is to smooth out the economy during periods of industrial instability. No, I don't think it is, Harlan. I don't agree. Finally, the indirect financial burden on the present law is far less than involved in Brownfield. Forcing a store owner to close his business on Sunday may well have the effect of depriving him of a satisfactory livelihood if his religious convictions require him to close on Sunday as well. Okay. Here we're dealing only with temporary benefits amounting to a fraction of regular week's wages and running not more than 22 weeks. Second, the implications of this present decision are far more troublesome than apparently narrow dimensions would indicate at first glance. The meaning of today's holding, as already noted, is the state must furnish unemployment benefits to one who is unavailable for work if the unavailability stems from exercise of religious convictions. The state, in other words, must single out for financial assistance those whose behavior is religiously motivated, even though it denies such assistance to those whose identical behavior, in this case, the inability to work on Saturdays, is not religiously motivated. If that was the point of comparison, I think you, Harlan, would be right, but I'm not convinced it's the point of comparison, because the statute seems to protect people who don't want to work Sundays based on their personal convictions. If the point of comparison was religious people who don't want to work Sundays versus people who just don't want to work or Saturdays, if the point of comparison was religious people who don't want to work Saturdays versus just someone who, for personal reasons, no matter how compelling, doesn't want to work Saturdays, I'd agree with his analysis. I don't think it's the right point. I don't think that's the right point of the analysis, for reasons the majority said. So I don't quite buy that. It's been suggested that such singling out of religious conduct for special treatment might violate the constitutional act limitations on state action. Well, no. As long as you're treating all the religions equally, you typically, according to Smith, of course, can teach religion. You can treat religion better than the secular counterparts. So there's not equal protection in that respect. But then again, religion does have a special carve out in the Constitution. So, yeah. My own view, however, is that at least under the circumstances of this case, it'd be a permissible accommodation of religion for the state, if it chooses to do so, to create an exemption on eligibility requirements for a person like appellant. Constitutional obligation neutrality is not so narrow a channel that the slightest deviation from absolute straight court leads to condemnation. No, I would agree with that, but I don't think the deviation is as small as you're suggesting. There are too many instances in which no such course can be charted, too many reasons which pervasive activities of the state justify some special protection for religion to prevent it from being submerged by an all-embracing secularism. I think he's right at the extreme edges. He's right at the extreme edges. Like there's gonna be again, like if their person's religious beliefs is I don't want to work any day of the week, right, then that doesn't make any sense either. So he's right at the edge. He's just not right here because we're not the edge. The state violates its obligation neutrality when, for example, it mandates daily religious exercise in public schools, with all the attendant pressures on school children that exercise entails. Right? But it's there, I believe, enough flexibility in the Constitution to permit a legislative judgment accommodating an unemployment compensation law to exercise religious beliefs such as appellants. Okay. For the very same reason, I cannot subscribe to the conclusion that the state is constitutionally compelled to carve out an exception to a general rule of eligibility in the present case. Those situations in which the Constitution may require special treatment on account of religion are, in my view, far and few between, which kind of cuts the other way, to be honest. If they're far and few between, then the administrative burden is relatively low because they're far and few between. So the as applied exception doesn't become that burdensome. So that kind of cuts the other way. And this view is amply supported by the Court of Constitutional Litigation in this area. Such compulsion in the present case is particularly inappropriate in light of indirect, remote, and insubstantial effect of the decision below on the exercise of appellant's religion, and in light of the direct financial assistance to religion that today's decision requires. For those reasons, I respectfully dissent. Well, Justice Harlan may be one smart cookie, but I disagree with him on this one, which is okay. I've disagreed with every justice, I think, at some point or another. Which is kind of in the nature of the field of law. Find me another lawyer I agree with 100% of the time, right? So yeah, I disagree with Justice Harlan's analysis here. And I think history has also shown whatever concern he had to be not realized. So I disagree with his analysis, but that's okay. We read it so we can understand. We read it, and we consider it. We consider it because we want to challenge. We want to challenge our conceptions, right? We want to read it and consider it and probe and consider that maybe Justice Harlan is right because Justice Harlan is a one smart guy. And so we read and consider his analysis and we give it its due attention, and I find it wanting. But we're better for the experience because we have tested. We have tested against a competing argument, the idea. So that was fun and exciting. I enjoyed it. So thank you, Mojo, for saying why I love you. I appreciate that. I do my best, and I appreciate all the love I get from all you guys. I really do. You guys make it all very, very worthwhile. So let me read some of your super chats. Let me just pull them up real fast. It's been a beautiful day today. All right. So we had 3 super chats. Jay Wolfenstein says, can you cover the one successful Solve Kit case? The civil case Bull versus Shit from the year 2525. I believe Judge Abraham Lincoln presided over the case. Soft sits do win occasionally, but they win in spite of themselves. They win in spite of themselves. But that's pretty funny, and I appreciate it. Kawari said, you literally can't work for me if you can't work Saturdays. That's my busiest day. It wouldn't make sense. I'd have to hire 2 people. Well, I don't know what to tell you. You can't discriminate on the basis of religion, so figure it out, I guess. And Erwin said, I would not enter into an employment agreement without my workday requirements agreed to. Is that something that only applies in the most recent years? No, not necessarily, but their ability to not hire you, I suppose, is more limited now than then. So, yeah. Bob Johnson says, thanks. You're the law tuber I watch when I want to learn something. The others are legal entertainment. Well, I'll try to make it more legally entertaining, too. Hopefully I'm somewhat entertaining. I'm amazing and we all love you. Thank you. Do I think the same decision would be reached today? Sure. If anything, I think it would go further than it did then. I think the court is more likely to grant more religious liberty than then. So I think it would go even further. I thought I was mistaken seeing the thumbnail. I'm absolutely besides myself right now. So cool you're covering this. I really enjoy your content and perspective. Yeah, thanks. The logo on the thumbnail is of course just the logo of the Seventh-day Adventist. Seemed appropriate since that was the subject matter. It's not religious though. It's based on that everyone's off day. Yeah, but if the reason you're not going to hire them is because religion, because they can't work Saturdays, like if it's your busiest day, presumably you could have someone else that would work. I mean, like they could take a Tuesday shift and the person who would work on Tuesday would work Saturday, and so you could just like one for one trade it. But you gotta accommodate people's religious beliefs because that's important. Sandra Ramirez says gives 5 gift memberships. That's very nice of you. Thank you. Unless you're telling me that your people like work every day of the week or something, which seems like bad. You probably shouldn't do that either. I am so happy this Daryl Brooks nightmare is over. I tell you, man, it was getting to me. It was getting to me. When is that case from the Florida woman who stabbed her boyfriend happening? Let's see, because I might do that one. Courtney Clenny. When's her trial happening? I think that's supposed to happen relatively soon. Let's see if I can find out. A trial date's been set. What did you set the trial date at? December the 19th? I might try to cover that. Yeah, I might try to cover that. Courtney Clenny out of Florida. That could be fun. Something to look forward to in December. Am I a good cook? I'm okay. What's my best fancy meal? Oh, I make a very good beef Wellington. I follow basically the Gordon Ramsay recipe, and I make a very good one. So I that's definitely my go-to fancy dish. Given the Reddit kerfuffle in the DB case, do you see a point where a case gets appealed to the Supreme Court for a trial outcome being influenced by mass streaming? Possibly. Sure. Yeah. All right, I'm going to go ahead and sign off, guys, if there's nothing more. I appreciate the 425 of you who are currently here. Some good channel news, by the way. The channel continues to grow slowly but surely. Very exciting. I am over 115,000 subscribers. Very, very exciting. It's growing slowly but surely, which is positive. Any growth is good. Any growth is positive. It means we're doing good things. What's coming up next on the channel is I will be recording regular content again. I have some Virginia CLE stuff I need to do. So I will try to do some of that tomorrow too. I think tomorrow, what's tomorrow? Thursday? I think tomorrow I might try to record some. So I might do a live streaming session for recording purposes for filming daily stories so I can go get back to filming daily stories because I'm completely out of edited stuff to release, I think. So I might do that tomorrow. On Friday, I'm going to probably do one of the Supreme Court Reacts. I'm probably going to do that before Law and Lumber's show because he goes so late, or he at least went so late Friday. Last time I was just dying in my chair. So I'll probably do that earlier in Friday evening and do a live Supreme Court React. It's either going to be the copyright case dealing with the Warhol estate, Andy Warhol, or it's going to be the pork case out of California. Some pretty good stuff going on there. So, yeah. Yeah, I think the colored lights behind me really do really help. I think I'm going to program in the rest of the color triad too. Like, because I've got, I think, let's see, I've got 5 of them. Yeah. So I've got 5 of the color triad programmed, but there's 12, or at least there is in the 12-point system, right? Because every color is the center of a triad. So I've got 5 out of the 12. So I might program the other 7 in, and then I have like the entire color wheel to choose from, which would be pretty cool. Where did I get the soundboard? This is a Stream Deck, and you can put in sound effect settings with Stream Deck. So it's a Stream Deck. It's very cool. And I just put in the Final Fantasy one for Final Fantasy 3 because it wasn't getting enough love. It's a good one. Final Fantasy. Oh, that's Final Fantasy 2. Or wait, it's one of them.
Emotional damage.
I make you smile. I'm glad. So yeah, so you got all these little soundboard sounds and stuff like that, and it's really cool. Oh, and I didn't really convert this to a sound yet. I don't know if I can do this. Oh, can I do this? Oh, this will be interesting if I can do this. In honor of Daryl Brooks, I was going to cut this down. Oh, this is trouble. This is trouble, guys. In honor of Daryl Brooks, should we do this one?
Smiled at me, said it's gonna be a good one, just wait.